Thank you, Polisi, and good morning, everyone. I'm very happy to see some familiar faces here. It looks like such an incredible gathering of people, and when I look through the program, I'm very jealous that I was not invited to be a participant, and also feel slightly sorry for you that you have to listen to my slightly less boring or more boring presentation than Stuart's. So what I would suggest we do is that I give you an overview of my organization, and through this introduction to what we do, where we do it, and how we do it, that we also start a conversation around around this sector that we work in, the sector that's termed the public interest law sector or the human rights sector, and I would be very interested to get some feedback from you. As Polisi said, I've been with LHR for 17 years, and I've seen many changes in the organization, not only in the people, but also in our approach to be useful as a human rights organization in a country which is marked by inequality, poverty, discrimination, and I'd like to share some of my thoughts with you. So maybe just by way of background, LHR, together with organizations like the Legal Resources Center, the Center for Applied Legal Studies, are part of a group of organizations that were founded towards the end of the 1970s. And it was founded at a time when the apartheid regime became even more oppressive, more brutal in its application, in particular through the declarations of the various states of emergency, and having sweeping laws, or laws that granted them sweeping powers of arrest, indefinite detention, and we've also seen the creation of units within the state security apparatus that was set up to oppress, to persecute, and to neutralize political opposition. So it was not an easy time for a bunch of bleeding hearts, human rights lawyers to get together and trying to provide practical legal assistance to victims of apartheid and opponents of apartheid. And looking back at the work that our colleagues did in those days really highlights the very different environment that we operate in today as human rights lawyers. Very rarely do we have to look over our shoulders at who's following us, or who's not liking what we do or say. Whereas in those days it was a much more difficult process, especially if you were a black human rights lawyer. But so my organization, together with others, focus very much on providing legal assistance to the political activists associated mainly with the struggle movements in the ANC, the PAC, and the others, and providing legal assistance to those in the criminal justice process, but also providing assistance to political detainees who are often held on death row. As you will know, the death penalty was still in force, and a number of political activists was executed. And it was also a time where we have seen massive displacements, forced removals of communities all over South Africa. And that's a very tragic part of our history, but it's also a fascinating case study of how lawyers use the law very creatively together with social movements, to obstruct, to disrupt, and to provide a means for communities affected by mass human rights violations to sorry. And because what they did was they knew that the laws were not on their side. So the laws permitted the apartheid laws permitted the forced removals. The legal system was dominated by white males, very much executive-minded judges who were very willing just to give effect to the abuses committed by the security forces, by government departments, but still the lawyers chose to make use of that and to frustrate this illegitimate legal process. So what did they do? They brought as many cases as they could to oppose evictions, because technically the law still allowed people to defend themselves and to be in court when an eviction is taking place, and they have overcrowded the courts, and it brought the whole legal system to a grinding halt, and that placed a lot of pressure on the judiciary as well as the executive to start to reconsider its position. But through the transition years after the Nationalist Party unmanned the struggle organizations, the ANC, and that whole period of transition was a very exciting time in our history, but it was also a very violent time. You would recall that I think it was probably the most violent period in our history, where we've seen an incredibly high number of people killed as a result of political violence, often instigated by the shadowy apartheid forces. So our organization, we had members across the country. We were then a membership-based organization and they played a role in monitoring the violence, depending on their position in society, played a facilitative role trying to bring down political tensions, reporting on human rights violations. And these reporting and monitoring were then used also later on, after the establishment of the Truth and Reconciliation Commission, in bringing these evidence to the Commission. Our organization also participated actively in the constitution-making process of the early 90s. And the reason for that is that many of our members and many of our colleagues then in the 80s already started a conversation that was taking place in various struggle organizations also, in imagining a new constitutional democracy, what it should look like, what should be written in a constitution, should it have a Bill of Rights, what kind of rights should be contained in that Bill of Rights. And we participated, our members participated in that, as well as we were part of a massive campaign led by the new government to get communities, groups, community activists involved in making submissions. And I've forgotten how many submissions the Constituent Assembly received, but it was, I think, it was more than 1 million. And I think it is worth remembering that process, because I think I can't remember and I can't recall a constitution-making process that came as a result of that level of public participation. And for that reason, I think our constitution enjoyed a fair measure of legitimacy following its adoption in 1996. That, of course, was only the first step in ensuring its legitimacy. The implementation of the rights contained in it was a completely different story. But if you compare our constitution-making process with the constitution-making process that occurred a couple of years ago in Zimbabwe, where there was very little public consultation, and where the public consultation took on a very problematic format, then I think one would realize the extent to which we can thank the parties initially who led that process. Okay, I'm going off track a little bit. So laws have always been important in our country, because in the apartheid eras, laws were used to persecute, laws were used to discriminate and to harass. And conversely, I think laws are and can be used in our new democracy to empower, and in particular our constitution can be used to transform. It can provide a blueprint for transformation in society. Again, I think we are not fulfilling that ambition, but certainly I think it is important that we use the today, 20 years after the adoption of the new constitution, as a time to reflect on the extent to which we have given effect to our constitution. So, as an organization, we really want to exploit the law and the legal system to find real protection, human rights protection to those communities and groups and individuals that we assist. And sadly, I have to say that although the laws have gone through significant reform and change, the legal profession has not gone through the same transformation. And as a result, access to justice remains an elusive aspiration for the majority of people in South Africa. And I'm not only talking of poor people in South Africa, but people like myself and you will find it very difficult to defend yourself to the extent that you need to hire a lawyer, an attorney, an advocate. It is extremely expensive, and the process is not always one that provides results very quickly. So that's our challenge as lawyers and working in the sector, is to challenge ourselves, challenge the system that we work in, and challenge the profession that we are all a part of. So my organization is made up of approximately 65 people. Most of them are attorneys, a handful advocates, and about 15 candidate attorneys. For those of you who don't know, to qualify as an attorney, you have to serve 2 years in a trainee program. It's called Articles, and after which you write an exam, and if you pass, you can then get admitted. And we operate through law clinics. Law clinics are basically law firms, where we employ attorneys, and we litigate. We bring matters to court on behalf of our clients. Over the years, we've developed a number of interest areas, and some of those interest areas have been developed into programs. So we have programs on refugee and migrant rights, land and tenure reform, on rural and urban evictions, environmental justice, penal reform or prisoner rights, gender rights, socioeconomic rights, and international justice.
And as I said, public interest litigation plays a vital role in the development of our constitutional democracy, and it's an important part of a comprehensive advocacy strategy that includes social mobilization, policy advocacy, public awareness, and research. And what do I mean with that? It's that the work that we do can never be divorced from a broader social mobilization campaign. Litigation and legal advocacy is but a small part of an ingredient of a much broader set of strategies and activities that could make up a transformative social program. So as an organization, because we've been working for almost 4 decades, we've built very good networks and partnerships with other parts of our society, whether in civil society specifically, whether it's the labor unions, with other social movements. I heard Stuart refer to movements like Abahlale and KZN. There are also the Right to Know campaigns, and the one, although there is different interest, we are not a homogeneous sector. People come from different perspectives, different social and political backgrounds. I have to say that over the last 20 years, I have seen much better collaboration and cooperation between various civil society organizations. And I think South Africa is, to some extent, different from other countries on our continent in that we have an incredibly diverse civil society. And I think and if it wasn't for that, I don't think we would have seen this political and social movement in our society over the last couple of years. So, just some background around our different programs. Our Refugee and Migrant Rights Program advocates for the rights of asylum seekers, refugees, and migrant workers. We assist marginalized migrants to access to basic civil and political as well as socio-economic rights. And we do that in line with our domestic laws, but also in reference to international instruments that we have ratified. That may include the UN Refugee Convention, the African Refugee Convention, and we utilize every opportunity domestically and regionally to highlight the plight and the struggles and challenges of asylum seekers and migrant workers in South Africa. It's an incredibly busy undertaking. We see approximately 10,000 clients every year, and even though that's a large number, it is but a drop in the bucket. South Africa has a couple of 100,000 asylum seekers and refugees, and so access to legal assistance remain quite limited. And for that reason, as I've said before, we are trying to be a little bit creative, and so my colleagues have started a very interesting new project, developing a mobile platform through which migrant workers and asylum seekers could use their handsets, their telephones, to get access to basic but targeted forms of information and advice on how to apply for asylum, how to apply for different visas, for newly arrived families, basic information around their survival, how to register your children in school, information around if you're a trader. Most often asylum seekers are compelled to work in the informal sector, and therefore they need information on how to register your little business, what to do if you're arrested,
And the amazing thing with this new technology, at least it's new technology for me, is that it can connect you with the closest service provider. Because you are geolocated, it can, if you need a lawyer, you can say, I need a lawyer. And, and if you're in Cape Town, it can refer you to our little clinic there in Green Market Square, or if you need social assistance, it will say you can go to this Garderen center, and if you're there, you can expect assistance in X, Y, and Z, but not this. Yes?
Sorry, what's it called?
We haven't given it a name yet. It's about to be launched, and that's one of the outstanding things. But yeah, it's using this USSD technology. But for those of you who are interested, speak to Selina. She will be able to tell you a lot more. And certainly check out our website and our Facebook page. It would be great to hear back from you. So one of the busiest undertakings of our refugee program is making sure that asylum seekers and refugees are people who have left their countries not out of choice, but because they were forced to leave their countries because of war, because of political persecution, and other grounds of persecution, is to make sure that they are protected here. And oftentimes our overzealous Metro Police and police departments would arrest asylum seekers before they had the opportunity to apply for asylum, or due to the long queues have not managed to renew their permits, or whatever the case may be. They get arrested, they are taken to Lindela, which is a detention facility on the west of Johannesburg, and our colleagues visit this detention facility together with other police stations, etc., to give legal assistance to people who are unlawfully arrested and detained. And then we bring urgent applications to the court. Well, we first negotiate with the Department of Home Affairs. Most often we fail to convince them to release them, and then we have to bring an urgent application to the High Court in Johannesburg and Pretoria, trying to convince the judge to order the department to release them. Now, it's a very cumbersome process, it's a very expensive process, but it's a very, very important process. And that's because in, I would say, 95% of the cases, the court actually orders the release. And because it is the judiciary who has made the order, the Department of Home Affairs and the police are then compelled to release. And that's the important thing about our new constitutional democracy, is that no longer is Parliament and the executive the supreme arms of government. We have all three arms of government, judiciary, legislature, and the executive, all have to adhere to the Constitution, which empowers the judiciary to give effect to the laws, and if policies or actions of any arm of the government contravenes the laws and the Constitution, the judiciary can compel them to follow the rules. So in the detention monitoring process, we see that happen on a daily basis, not on a weekly basis. We've also started a very interesting initiative about 5 years ago around the right to nationality. Mainly as a result of the growing numbers internationally of people who have become stateless. In other words, who could not, through the application of law or the operation of law, not find a confirmation of their nationality, and have become, in effect, stateless, people without a country. And we started a little project on that, trying to document these cases, what led to these people to become stateless, what kind of practical remedies can be found to assist them out of the statelessness, because without an ID document, you can imagine in South Africa, and are most of you from South Africa? Not.
Well, any country, without a national identity document, it becomes so difficult to survive and to operate in your society. You cannot register your birth sometimes, you cannot be registered at school, you cannot get a driver's license, you can be arrested for not having such a document, and it almost becomes an access to the protection of rights. So for those of you who are interested, also go to our website. There's a lot of interesting discussions around the prevention of statelessness and the protection of stateless persons. Then the second program is a program focusing on land reform and housing and evictions. And this is a very important program that started in the apartheid years in our organization, when we tried to assist and when we tried to prevent people from being forcefully moved off the land that they've lived on for generations, where they are forced out of their homes that they lived in. And one of the first laws adopted by Parliament was the Restitution of Land Act that sought to allow those communities, those families who have lost their land as a result of the 1910 Land Act, that allowed the government to forcefully displace large numbers of people off their land to claim that back. And that's through the land restitution process. And that's a very important process, and one of those processes that we as a society have not achieved what we set out to. Because if you look at the land ownership in profile in South Africa, you will see that very little progress has been made to return land, to restitute, and to deal with one of the most serious legacies of apartheid. And in fact, I just came from a constitutional court hearing where the constitutional court is asked to consider a decision by the government to reopen the land restitution process, because there was a deadline. I think there was a deadline of 1998 before, when those communities who have lost their land had to lodge a claim and an application to have their land returned to them. Unfortunately, the timelines were too short, and many communities, for whatever reason, could not make those applications. Now, the interesting thing, if I may just quickly talk about that, is that you will find today in court human rights organizations on both sides. So our friends in the Legal Resources Center, they are arguing to say that the government is doing more harm than good in reopening this process, and they say so for very good reasons. They say, it's going to delay the process further, it's going to require a mountain of resources that we don't have, blah, blah, blah. And the process that the government followed to reopen it was unfair. On the other hand, you have the government defending its decision to reopen it, but you also have communities who have lost their land to say, we did not have an opportunity to lodge our land restitution claim, and we're desperate for this opportunity, and we represent one of those communities. But that, for me, is an example of how a constitutional democracy should work, where complex human rights questions are debated, and in the end, a very competent bench of independent judges that represent our society, not yet perfectly, but can consider the merits of it and the constitutional validity of these arguments, and then can come up with a decision that would take us forward. And so it was wonderful listening to the arguments made in court. But similarly, last week we also had the Constitutional Court considering the whole Nkandla report of the public protector in South Africa. Now, Nkandla, do you all know what Nkandla is? So, and again, I mean, I was so proud of our court in asking the difficult questions in a very respectful manner, respectful of the government, respectful of the public protector, respectful of the various organizations involved. But it was very independent in doing so, and I can't predict what it's going to say, but I can definitely say that in its judgment, it would have felt free to give a judgment that is made according to their best interpretation of the Constitution. We may disagree with it, but I think unlike what is happening in Lesotho or Swaziland, judges here do not have to look over their shoulder. And we have to protect that, because I think we have seen in the past that some politicians, even the president included, at times felt, the need to criticize the judiciary, and maybe criticize it in a way that kind of undermined their independence. But when it happens, I think there has to be a response, and that response has to come from everywhere, because I think our difference in perspective matters when we give social commentary or we respond to these things. So anyway, so back to the land reform. That is a program that I think, unfortunately, has not achieved its objectives, not within society nor within our organizations. We are currently involved in a case, the Garderen case. It's a massive community that own big swaths of land in the Free State, Northwest Free State area, and they were given that land back, but they are still not on the land, and mainly because the government has not given enough post-settlement support. In other words, giving them the means to return and the means to re-establish themselves in an economically viable manner. Let me move on quickly. A recent addition to our organization is a program that looks at environmental justice and providing legal assistance to communities who are affected mainly by the extractive industries, mining companies, and although we address it through different lenses. On the one hand, we have the environmental justice lens, making sure that the mining industry in particular adheres to our environmental laws, so that the damage that they cause are not left to our subsequent generations to deal with. That the pollution and the environmental degradation are dealt with in a responsible manner, and that mining, which forms a very important part of our economy, and nobody can say we can live without mining. I think mining has always been and will remain an important part of our economy. So as an organization, we are not against the existence of the mining sector, but we certainly are against the way in which mining, and especially the big mining companies, have conducted themselves over many, many decades. And we think there's a serious need for a very difficult discussion around the impact of mining on our environment, the impact of mining on communities around mines, who benefits from the mines, and how do we go about in limiting the degradation that follows mining. And so this program is very active in that field. The problem is that, we've litigated against the government for a number of decades now. And I have to say, litigating against our government is much easier than litigating against big multinational companies. Because, for one, I find government to, even though it's often a battle, they follow the process better. They are less likely to come after us as an organization, us as lawyers, and so the risk for us as an organization is much higher litigating against big multinational and South African corporate interests. And I think, if I can say that, I do think the jurisprudence, the case law, the judgments protecting the rights of people have been much more comprehensively described in judgments by the courts where the government was the so-called violator. And the courts are a little bit more reluctant in giving compelling non-state actors, companies, and holding them to the same level of compliance than they are with our government at its various levels. So for us, that is a big challenge at the moment. But we are fortunate to work in a close network with organizations across the country and indeed across the globe. We work with organizations and communities in South America, in the Congo, in Mongolia, who fight very similar struggles, and we have learned a lot of useful lessons and gotten very useful advice from activists and lawyers in those parts of the world. And so therefore these being connected and plugged into networks is crucial for the work that we do. So that about environmental rights. Penal reform. So prisons and prisoners have always been a part of the work that we do. And it's firstly because in the apartheid years, we detained human rights activists and human rights defenders left, right, and center. And through our legal assistance to those human rights defenders, we've also come to see and observe the deplorable conditions within which people were detained. So our interest in that stemmed from those years. And over the last couple of years, we've rekindled our interest in that, and we've set up or re-established our penal reform program. And in this program, we look at mainly the poor application of our correctional services legislation. And as the title would imply, our legislation, its main objective is correction. It is reform and allowing offenders to change and to allow them to reintegrate into society. Sadly, that's not happening. You go to any prison around the country, and you will come back with an impression of punitive objectives rather than corrective objectives. And so we work again in a network of organizations to try to convince government through advocacy as well as litigation to change our approach to correction. So we can talk about that a little bit later if we have time. We also have a program around gender in the broader definition of gender, and that is a recent program that allows us to better describe the plight better describe the gender aspects of
communities and issues that we're involved in, whether it is the gender-based persecution of LGBTIQ activists coming to South Africa, finding recognition of their persecution and finding protection for them here, or addressing the lack of institutional mechanisms to deal with high levels of gender-based violence in South Africa. And so we very concerned about that. So maybe, I know I only have 5 minutes left. I just want to quickly make a few points around the use of the law and the legal system in bringing social change. And as I've kind of alluded to in the beginning, there are definite benefits, advantages in using the courts and the legal system to secure protection to people affected by human rights violations. And those benefits can take different forms. On the one hand, you will have the traditional outcome where a community was threatened with eviction. We managed to bring an interdict against the landowner, and they are allowed to continue with their occupation, their residence, or whatever of that land, building, or their project. So it's an outcome for that particular group or individuals. But it can also, yes.
Sorry, could you please just repeat that?
So the obtaining an outcome for a group, a positive outcome, a result for a group or an individual. So that's one benefit of the law and the judicial system.
But you gave it like a collective name in the beginning.
I can't remember.
Lots of cases of using the court as a legal system.
And I must say, I got this from a report that was done recently by a group of organizations, Stewart's organization, drafted the final report. And for those of you who are interested, contact me, I'll send you the report. It's a really useful and a practical report. It gives an independent overview of or analysis of this public interest sector. The second benefit that they list is changes to the law and policy, and I think that speaks for itself. We've seen several policies and laws being challenged, and indeed are being challenged as we speak in the Constitutional Court. My organization is also going to the Constitutional Court very soon, where we have challenged the Immigration Act in South Africa, to the extent that it does not allow a person who has been arrested and detained in terms of the Immigration Act to be brought before court within 48 hours. In the same way as criminal detainees have to be brought before the court. And our Article 35 of our Constitution, our Bill of Rights, gives every person that right to be brought before. Anyway, so that's another example. Then I think other benefits can be institutional changes, where institutions are strengthened through litigation. I'm thinking of, remember the Glenister judgment of the Constitutional Court that said that the Hawks, the specialized agency, has to be independent, and blah, blah, blah. So I think that's also a potential. It can also expand the democratic space. In other words, the legal system can give access to communities and groups who were otherwise excluded from political participation, access to a political process. It reminds me, some years ago, we represented the Mutsi community. It's a community that is located on the border of the Limpopo and Mpumalanga provinces, and they were moved from one province to another through a municipal demarcation process that changed the borders, and they were very much opposed to that because they felt it would have real socio-economic implications for them.
So no matter where you stand on where they should be, in which province they should be, the main argument and the main reason why we felt we should represent that community was because they were ignored through that whole decision-making process. And it's a community that is way out. They don't have access to lawyers and they don't have money to pay lawyers. But through the long-winded litigation process, we managed to secure them a place around the table where those decisions were taken. Unfortunately, eventually the decision didn't go that way, but at the very least, they participated in the decision. Okay, so those are our potential benefits of using, but there are also limitations, and I'll just mention a few. One is using the law and the legal system. Dragging somebody to court doesn't make friends. So we have seen that we litigate against the Department of Home Affairs very regularly, and unfortunately, since we started doing that about 8 years ago, we've seen that it has kind of we're no longer receiving Christmas cards from them, and so it limits our ability to resolve matters before it goes to court, and that's a pity. It has reduced our ability to engage them in a constructive discussion around policy reform and this and that, and that's sad because I think it's from both angles. You know, from our side, we don't have the opportunity to resolve matters before it goes to court. On their side, I think they lose out the benefit of engaging with, I think, an important organization in civil society. I also think that cost is a limitation. I mentioned it before. It becomes very difficult and very expensive to use the courts, and that also goes for us as organizations. We often have to brief outside legal counsel advocates to help us to argue matters in court, and that costs money. And in our tough economic climate, I think getting funds and funding are becoming more and more difficult. So we have also seen an increase in the way in which enforcement agencies in our government use innocuous legislation for ulterior motives. So a good example of that would be the way in which the Gatherings Act is being used. The Gatherings Act was written to allow and to facilitate social mobilization, to allow communities and groups to get together, to protest, to mobilize, and to engage. Unfortunately, the way in which it is being applied is a process to exclude. In the same way as PAIA, the Promotion of Access to Information Act, which is again an act that was written to give effect to the constitutional right of access to information, but the way in which it is applied is to prevent access. And information that is supposed to be available over the counter or by just a mere request are now being thrown into a bureaucratic process with a lot of red tape and procedural hurdles that makes it very difficult for you and I to get access to information. So that's unfortunate that processes that are supposed to be accessible and easy to conduct are being taken to the courts. And unfortunately, it places undue political pressure on our courts because decisions that are really supposed to be made by the executive or the legislature are not being made, or that responsibility are shirked, and as a result it's taken to the courts. And so too many cases are brought to the courts, and that creates tension, unnecessary tension, between the executive and the judiciary. I think, Mkhulisi, let me stop here and allow us
a little bit of time for interaction. So if there are any questions or comments or criticisms, I'd be happy to hear.
What kind of people do you take to work with you in order to realize your objectives?
So our organization is mainly made up of lawyers, but it's not limited to lawyers. In fact, some of our most effective colleagues are either social researchers, we've had historians, we have educators, we have community activists, and we try our best, although our primary tool is using the law and the legal processes, we very much realize that it's all about telling stories. And the lawyers are the worst storytellers in the world. You only have to read a legal document and you'll realize we use language that you cannot understand, and it's boring and it's black and white. And so you must go to our website. We have films. We use films. We use all different types of strategies to raise the issue, the plight, the story, and so we try to employ more than just those.
You touched on the situation at Home Affairs. Are you guys aware of what's happening? I'm sure you've got the update of the reports and everything, the human rights violations that are happening, the Shambok happening on foreign nationals. So if there is, what do you guys intend on doing? Because there's no progress. I was there last week and the same thing is still happening.
Yeah. So we are aware of that. My colleagues are there on a daily basis. Sadly, our presence there and our assistance to those people standing in the queues have been mainly limited to providing those individuals some assistance. Our litigation over the last 10 years have brought minimal systemic change to the way in which asylum seekers and refugees are protected. And that is, it's a difficult realization because I would have hoped that the very progressive jurisprudence on refugee protection should have brought about a more compassionate, a more effective and fair administration. So what do? We take matters to court, we get the judgments. One of the big problems human rights clients have at Home Affairs is the high levels of corruption. And that corruption happens in different ways. So it starts in the queue. There are these operators that say, give me 500 Rand, I'll get you to the front of the queue. That may not be as a result of, that guy may not be an official, but he works with an official. So the officials, they have their backdoor channels, and so we've done a 2-year study on the impact of corruption as well as the modalities, how corruption takes place, and we've launched that, and we have presented that to the department to say, this is what we have found, do something with it. And they promised to do something. We haven't really seen the effect of what they're busy doing, but we hope that, and if they don't do something, then we have a base level to kind of measure their promises against, because we can say that 4 out of every 10 persons experience corruption in the following ways, and if we do another survey of this kind 2 years down the line and we say it has not produced, we can say whatever you've done, it has come to naught. Sorry. So you, Aslam, you first, then we'll go around that.
So I had a whole lot of questions, so if you mind if I just ask them, and you can choose which you answer. Okay. So I've got a few questions. I'll ask them all, and whichever you want to answer that you can. So the one is, I read your submission when the Immigration Act was still a bill. So what are the procedures of like your submission being considered to the final realization of the Act? Because clearly it's like, you know, the unabridged birth certificate thing was a problem, and yet nothing, it still made it through. The second question I had was, using the law in international matters, so we've got the Constitution over here, but how do you use the law to advocate for, say, like trade treaties that are unfair and unjust and will lead to issues? And then you spoke about the consultative process in the drafting of the Constitution, and that seems like a very meaningful consultative process. Whereas today there's a lot of consultation that happens that is rather meaningless. And then finally, I think just the Lindela case, the privatization of that whole facility troubles me deeply, and I'm not sure if you have thoughts on that.
So let's start with the privatization. I think we privatized way too much important government functions. And I'm not saying that only from a political opposition to the use of privatization, but also because of a practical consideration. Because I think once an essential government function is privatized, it becomes very difficult to hold that private entity, in practice or through law, accountable to the same levels as we would government. And that goes for Lindela. Lindela is a very good example, but it's also the private prisons. Private prisons are, through its operation as a private or non-state service provider, a lot more difficult to hold accountable. And there are many other examples. I mean, I find that abhorrent that we have to now apply through a private company for a visa or work permit. For what reason? To what end? Just because we admitting that we are too corrupt and inefficient to receive those applications ourselves? It's an indictment of that department. Anyway, but it's an international trend also, unfortunately. Your first question...
The immigration submission.
Yeah, so I have to say, I mean, it is something that we work very hard at, is to participate in the law reform process. And although we are not usually successful, I think we have seen some success at different times. Initially, we were very successful in the drafting of the Refugees Act. There was a very an open process that allowed civil society throughout the drafting process to do research, to give technical submissions, and a lot of that, in the end, were incorporated in the Refugees Act. In that sector, I think we've become less effective, but it's not unique to Home Affairs and Immigration. I think you would also find it in other sectors. I think there's a growing distance between civil society organizations who have traditionally played a positive role in law reform and policy making. Although we can't make policy, we're not the legislators, but I think it's important that the policy making process includes submissions from civil society and community. So that's taking place less and less, and there's a growing body of analysis, but also jurisprudence reflecting on this poor consultation processes that are taking place, despite very clear obligations written in the laws for that to take place. So but we continue to do that, and at the same time, I think I must also just mention, with regard to international law, there are all kinds of opportunities that we as South African civil society do not exploit enough to give feedback into that peer review mechanisms, whether it happens at the UN or at the African Union level. And you know, South Africa has recently ratified the International Convention Covenant on Economic, Social and Cultural Rights, which is an extremely important international instrument. It's one of the founding pieces of international human rights law, together with the International Covenant on Civil and Political Rights, and of course the Universal Declaration. And in terms of this covenant, our government must not just say, okay, we intend to protect these rights and respect them, but we will also give reports to the international community, to our peers, on our progress and in implementing it. And that process of reporting also allows for us to participate in that discussion. You know, we can say the government has done really well on this, you know, on the issue of healthcare or education is a big problem. Certain groups are excluded, like undocumented migrants, whatever. So and I think it's an important part, and it's, so that discussion, I think, potentially exists outside South Africa.
Sorry, I don't know which took that. Just to go back to the question where we were talking about the lawyers visiting that situation daily. I wasn't familiar with that case or that. Your question where you said, have you been to?
Yeah.
I just didn't know the reference.
Oh,
was that a Home Affairs office or what was?
Yes, yeah. So the again, you can, if you go to our website,
Yeah.
you'll find the case reference on it, as well as I think we've posted the judgment of the High Court in Pretoria. But that will now be referred to the Constitutional Court for confirmation, because it dealt with a finding that that provision was unconstitutional, but it will also be appealed by various parties. And is that what you wanted to?
I just know what was it? Was it a Home Affairs office that was something?
Are you talking about the place where the refugees?
I was asking what your question was.
No, I was just asking about, you know, where they go and seek for asylum and all the permits. Yes, that's where they queue but they are not getting the service.
Oh,
that they're
okay.
supposed to.
And there's violence.
And there's violence and
Oh.
beating up and all those
Okay.
things.
Tunisia is actually, that case is a very good case study, showing the limitations of the litigation process in bringing systemic change, because LHR, the Legal Resources Centre, and various other organizations have tried to address the serious problems at these refugee reception offices, and because it can be broken down into many sub problems, but the big problem is access to the asylum system, and without access, people remain vulnerable to arrest, detention, and return to a country or a situation where they would continue to face danger. So what we have done, for instance, is with regard to the Pretoria office in Marabastad, we have monitored the situation over a period of 6 months. I think it was 6 months. And on a daily basis, we counted people in the queue. We counted the number of people who were assisted. We counted those who were not assisted and who were told to come back on the following day. So we went to court presenting this evidence, and the court had no difficulty in finding the current situation to be unlawful. But that's not the problem. Even if you go to the Department of Home Affairs, they say, yes, no, it's unlawful. For whatever reason, we're failing to assist them. The question is, what can the court do to remedy that? So, what did we do? We then asked the court to play an active role in ensuring that the department does something. So we said, the department in their papers, they say, we just don't have the ability to deal with the situation. So we said, okay, the court has to order the department to appoint an independent process engineer, an expert who could look at the problem and come up with procedural solutions to say, you have this many people in the queue, how can we improve our system, our processes to be more efficient, to assist more people, and to improve the quality of decision making. The process engineer did that, and it had some effect, but not a real, unfortunately, I have to say. So, and then another case was, or series of court cases, was around the decision of the government to close the refugee reception offices in the city centres in Johannesburg, in Port Elizabeth, and in Cape Town. And all these cases were successful. In all of those cases, the courts found, for different reasons, that the decision to close them down were unlawful. But up to today, all those offices remain closed for newcomers, and for different reasons, but mainly because the department has adopted an attitude of malicious compliance. So it said, we adhere to the legal process, but you have a right to appeal. But then they would take months to lodge their appeal, and when they are late and whatever to file their appeal, they would ask for condemnation. And as a result, this matters have been going to the Constitutional Court, to the Supreme Court of Appeal, and the Supreme Court of Appeal just recently again said you have to reopen the Port Elizabeth office by, when was it, Sabina? It was like last month sometime, and it's still closed. And they've now asked to postpone that for 6 months. Anyway, but what it shows is that litigation alone cannot always bring the necessary institutional or whatever transformation. And litigating in this sector is slightly more difficult because I think for very good reasons the migrant and refugee communities feel more exposed in taking to the streets. They have much less political agency than South African communities have. They have struggled to integrate their plight with other social movements. I think it is taking place more and more. I think we see trade unions being more interested in incorporating them. But anyway, that's a discussion maybe for another time. You had your hand.
Okay, just listening to what you said, I can understand that litigation does not really have, it is powerful, but it needs more help, I guess, manpower. And my suggestion was, what about the South African Army? If you look at the fact that the South African Army has to go to other African countries sometimes, get deported and assist, war type of situations, something like this, I know that it's not war, but, dealing with violence in queues or being observers at offices, etc., for the government, because they do have a high authority than citizens according to their constitution. Why can't we use the South African Army?
So an army is an institution set up to fight. They have a very clear mandate, and they are not trained, nor do they have really the mandate to perform policing functions. And so when they are used for that purpose, it's often a very blunt instrument. And often they do more harm than good. But the armies can be very effective in preventing major human rights violations. And our army has played a very positive role in certain instances in peacekeeping in other parts of the continent. So yes, our army, they have also provided humanitarian assistance when there were natural disasters. And you will remember the Mozambican floods about 10 years ago. The army did incredible work in providing assistance. But we've also seen the army being human rights violators in Operation Fiela that Stuart referred to earlier, where they also kicked down doors, dragged families out in the early hours of the morning out on the street and arresting them. So yes, but we have to do that with yeah.
Because I was just about to say, it's not only about peacekeeping, part of the United Nations looks at peacekeeping, it's also about peace building. Yeah. And peace building is a different type of training. And right now the South African Army is kind of destitute, they don't really have much to do. And they've actually opened applications to citizens who have different qualifications, whether it's economics, etc. And in that army, you're going to qualify with that. So you can even be a lawyer/army person. And I don't know if that's good, because essentially you could use that as a resource to help you within your litigation. You also create employment as well for people, women, youth, or whoever who needs it. And some of the, I don't know if it's the qualified migrants or whatever, but it's going to be something that you don't have to look for extra resources elsewhere. It's right here. And they are opening applications to people. So I don't know, it was just a solution that I thought might help you guys.
Thanks.
You mentioned something about you doing some projects on environmental rights, especially in the mining sector. Like, there is an issue that concerns me, like when it comes to access to water. Like, if you look at the newly opened mining Hosiden, in Women actually they are doing they're going to help us when it comes to generating energy. And like you said, that we cannot do without mining in South Africa. Like 80% of our energy actually comes from ore mining, so we do need them. But then, like I was reading a document about Lucid, and they said that they use approximately like millions of liters of water that they're going to be draining from our fresh river systems, especially like from the wall, to actually process the mining activities going on there. And I was wondering if there's kind of legal kind of tools that you can use to prevent such activities, because I think they can use like maybe recycled water or water from the sea. Right now we have a water crisis in South Africa, and if you're going to be using millions of liters, from our fresh river systems to kind of, help them with their mining activities, and you leave the poor people like the water the most, without the water. That's kind of, like.
Absolutely, I think water is a crisis. Access to clean drinking water is a massive crisis. But the solutions to the problem that you've described are not that clear. So everybody would agree that we should be less dependent on coal-powered power stations. But what's the alternative? The alternatives are environmentally friendly modes of generation, and I think we see a gradual move in that direction, and we also see a reduction of costs offsetting that up. But for me, the role that we can play as a legal organization in preventing water pollution is to hold the government accountable to use its enforcement mechanisms to make sure that those Mpumalanga-based coal mining companies adhere to the environmental laws, so that they don't operate without a water license, that they do not pollute the way in which they are at the moment, and when they pollute, that they do whatever is required of them to clean up the pollution. And that and also that we use the law to hold the polluters to account, the mining companies. The problem is often that the Mpumalanga rivers are all polluted almost, but it's very difficult to pinpoint the actual polluter, because there are so many companies that pollute the water, and it's but we have to start somewhere. It's like somebody say, how do you eat an elephant? It's by one bite at a time. And that, so the little role that we can play as activists and organizations, I think, can amount to something bigger, and that it has to be coordinated and linked. But so our focus would be on an enforcement level.
Sorry, before we continue with questions, would it be okay if we maybe formally conclude the session and then whoever has questions speak to you?
Yeah.
Okay, I'll just hand you over to
Okay, on behalf of our fellows, we'd like to thank you for coming, taking your time. Thank you very much, you learned a lot. Can we just give a round of ran out of time.
Thanks. Can I just say one thing? So, if you're interested in continuing in these kinds of discussion, usually in July, there's a gathering of activists, lawyers, communities, academics at Wits University. It's called the Public Interest Law Gathering, and it's open to everybody. It's free, and I really urge you to attend that. The second one is last week in August. The International Federation for Human Rights, FIDH, will be hosting its World Congress in Braamfontein. And it brings together member organizations, human rights organizations from about 200 organizations from 112 countries, together with local human rights activists and organizations. And if you're interested, contact me, and we will make sure that you'll be able to participate.
Thank you.
Thank you very much.